to fulfill, to accomplish such tasks on the part, not only on the part of the faculty members, teachers, professors, but also on the part of the administrator, also on the part of the vice chancellors, also on the parts of our UGC, University Grant Commission, and Bar Council of India. So far as the teaching method is concerned, in our country or even in the world, there are these major lecture methods are being used in propagating, in imparting the legal education, that is lecture method, case method, problem method, discussion method, simulation and role play method, collaborative teaching method, seminar method, clinical method, which I have discussed in very detail, other methods. Lecture method, I had told you that it should not be monotonous, it should not be motionless, it should not be static, it should not be predictable. It should be dynamic. The involvement of the students must be there. The students should attract towards your lecture, what the sir is saying, what the new thing sir is saying, what new case is being referred by my teacher. Such curiosity must be developed in the mind of the students. And for that purpose, we have to do some work, some labor. So far as the case method is concerned, I am quite confident that if you would like to interview 100 students of different private colleges in Lucknow and ask the question with them, then whether you are capable to sort out the cases from the All India Reporter or Supreme Court Cases Journal, if I am giving you citation, I am sure that only 40% will say, yes, I can do. That is not good thing. In 100 students must give answer in positive. They must know how search the cases in the journals. If you are asking that whether you are capable to segregate the part of the ratio descendi and obiturator in the case, in the particular case, majority of the students will say no, I don't have any idea. How it could be possible for me to make a demarcation line between obiter dicta, part of the obiter dicta of the case, and ratio descendi of the case. It is our duty. And we can do it by our extraordinary efforts, by our sincerity towards our students, by showing our more concern towards the future of our students. We can do it, and we have to do it. That student must know how and in what way, when he will enter into this professional life, to do the things, to do the work with the legal profession. Clinical methods in legal education, in the words of Dr. N.R. Madhav Menon, he also given much more emphasis, much more importance to the clinical method, and important changes are to be taken, which is inevitable, which cannot be avoided. अगर अभी हम नहीं कर रहे हैं तो थोड़े दिन बाद करना पड़ेगा. तो why we are not starting right now today? Holistic development of learners by reduction of curriculum content to enhance essential learning and critical thinking. Our efforts must be in the direction to prepare our students to start thinking critically, analytically, not theoretically by just going through the textbook and material available in the black and white form. If particular provision, legal provision is applied over such a situation, how, why, at what extent, at what extent the remedy is given to the party by applying the particular provision, all such critical thinking must be in the mind of the student. in the mind of the researcher. Effective teacher recruitment and deployment, that is the basic problem of our legal teaching system. Neither our governance nor our private sector people are thinking about the teacher recruitment. They are very much controlled regarding the recruitment of the teachers. जहाँ पर 10 टीचर की जरूरत है वहाँ पर 4 से ही काम चलाओ, that is sufficient. क्यों? Because वहाँ पर पैसा बच रहा है. That tendency can never be helpful for our legal teaching process. It is the exigency of time to establish the national for outstanding research proposals across all disciplines. There is no provision at all. If some of my learned faculty who are added here and listening me have made a very outstanding research program, there is no provision to give them reward or award. कोई provision नहीं है, कहीं से no encouragement at all. Even nowadays, University Grant Commission has restricted so many funds for the particular objectives. That is not very fruitful for all of us, for all the entire legal teaching system. Curriculum to reflect socio-cultural context and multi-integral education. National Repository of Educational Data will maintain all the records related to the institutions, teachers, and students in digital form. This effort is admirable. In this way, all the data, all the records, all the study material is converting day by day in digital form. And at last, a competent class of faculty is the foundation of the progress of legal education, not merely in India, but all over the world. This fact is existing. Otherwise, the future of the legal education all over the world is bleak. In our country, there is no separate law university in all states to govern the educational institutions. The law institutions are presently affiliated to the universities, state universities especially, which already have much more burden of different faculties like management, arts, science, commerce. उन्हीं में एक law भी है, which is giving adverse effect on the curriculum, on the syllabus, on the entire running of the law department, and which is not very good for our entire legal education system. One more very important problem, impediment, which is taking place and getting serious day by day. Mushroom growth of private non-graded colleges is seen everywhere. These colleges are ill-equipped, no student facility, even no adequate library facility to the students or teacher, and only just on the shoulders of some part-time teachers, they are being run. That is not a good sign for our legal education future. The vacancies of permanent teachers are not filled, perhaps due to lack of qualified candidates, and of course due to malpractices in recruitment processes. It is a very huge problem, and it is the backbone of the entire legal teaching process in India. It should be checked and controlled, and immediately vacancies of permanent teachers must be filled with the qualified candidates. We don't have dearth of or scarcity of any qualified teachers. Now, those days has already been passed. जब नेट नहीं मिलते थे, JRF नहीं मिलते थे, PhD नहीं मिलते थे. Now it is the time when we have adequate sufficient number of qualified faculties. If a person now, what is the effect of all such things? Effect is this, that the student or person has nothing to do. Whenever he has nothing to do, then they join law course. And that is the real state of affair. Though I have not to discuss these facts in this program, but it is the reality. We have to be acquainted with all such bitter realities of our surroundings. Traditional chalk and talk method of teaching is still adopted in majority of law colleges for teaching. Neither the teachers are motivated to use modern technologies like computer, projector, discussion method during the course of their teaching, nor the students are being encouraged. So listen, we are running or living in the information technology age. ये बहुत दिनों तक चल नहीं पाएगा. We have to change ourselves. We have to make the provisions in the form of infrastructure, in the form of means, in the form of funds. Otherwise, this system will not procure a very good future in our country. We were discussing about the clinical method of teaching. All such thing is feasible, possible in case of urban areas. We are sitting in Lucknow, those who are sitting in Delhi or Bombay or big cities. But think about those students who are staying in rural or micro-rural areas. No proper practical knowledge of rural students. They are getting just theoretical knowledge. And in the scarcity of the sufficient faculty members, they are also not capable to attain the sufficient theoretical knowledge of law or advocacy. That is a very pathetic situation, and it should be controlled and it should be taken into consideration. Tell me, compare the student of National Law University situated at various states of India and a student of private college or aided college or simply university college student. You will get a huge difference between these two. Their capabilities will be entirely different. You cannot equate both of them at the same time. This is not a good sign for our future endeavors. There must be accessibility for all of the segments of the society, especially those segment of society, those section of the society who are economically challenged, who are poor, who don't have sufficient means. Then we can say that we have an effective legal teaching system. Otherwise, we don't have any right to say this thing. Accessibility by all sections of the society must be ensured. So, I think in these words, time is about to be finished, but just I would like to take 5 or 10 minutes. That is the aspect of globalization on our legal education. That is the last aspect, which is we want to share with you. If you permit, then I may continue. Hello?
Yes, sir, you can continue.
Okay, thank you. Thank you very much. Globalization has thrown up new challenges to legal education and legal profession as well in India, as well as at the global level at large. To meet challenges of globalization, a lawyer needs to have vision of emerging problems, zeal to serve the the cause, justice, and the ability to forge new tools and technique appropriate the changing needs of and times at present our legal education system. Our legal education system is inadequate to task the ahead, calling for an all-out of efforts by taking free and fair society. आप देखिए हमारा जो सिस्टम है वो ग्लोबल मार्केट के अकॉर्डिंग मेजॉरिटी में लीगल लॉ स्टूडेंट्स को नहीं निकाल रहा है. दे आर नॉट finding themselves very much fit for the global marketing, for the foreign firms, legal firms. How can you expect with a student of a private college that he will serve the international or foreign legal firm in a successful manner? So it should be considered, this point should be considered. And for that purpose, again, the question of funding, the fund problem and question of resource will be occurred. A successful legal system provides all the facilities to fulfill the requirements of the people. And for that purpose, at prima facie level, we have to make the compulsory the study of certain subjects like intellectual property laws, cyber laws, biomedical laws, bioethics, space law, environmental law, comparative international laws, international advocacy, etc. These are the subjects which may be very much helpful for their international or global market. A kind of autonomy, flexibility, and freedom should be given to law schools, particularly the departments in various universities of the country, the law departments which are running by getting the affiliation of the various universities. इनको ऑटोनॉमी दीजिए, फ्लेक्सिबिलिटी हुई है इनके लिए. Legal education should be sorry, and legal research should be promoted and should be given impetus so that the quality of legal education can be ensured. These are the certain suggestions, certain points of discussion which I have presented before you, and your people, patience, given me impetus to linger on this discussion. Thank you very much. Akanksha madam, thank you very much.
Thank you, sir, so much. You have addressed the one of the most important topics, like clinical legal education, and most importantly, you talked about research. I'm sure all the participants have learned a lot about research. As we all know, without research, a faculty cannot grow. Thank you so much, sir. If any participant is having any question, they can ask, sir.
Okay.
I think no participant is having
Any
any
question?
question, sir. No, sir. I think no participant is having any question. Thank you, sir. Thank
Okay.
you so much.
Okay.
Thank you.
Thank you very much. Thank you.